Thank you very much for inviting me to this wonderful conference. And for this conference, I decided to go back to look at some of the early writings on space from the later 50s and the early 60s. And what I found was that from the launch of Sputnik in this period, in the late 50s and the early 60s, there's always been a great deal of concern with many of the issues that we're talking about today, the potential for sovereignty or property rights in space. And you can actually see this by just looking at the titles of some of the more recent works, including Michael Byers' book, Who Owns Outer Space, Who Owns the Moon, a book by a philosopher published in 2024. And you look to what are the titles of some of the things that were written in the later 50s, early 60s, Who Owns the Moon, Who Will Own the Planets. So there's been this long-standing, multi-decade concern since humans first started going into space with what humans, there's always been this assumption that humans will control, but what humans will control outer space, and how are they going to be governing outer space? So what I did is, after kind of looking at some of the general readings, I decided to focus on the work from this period of the late 50s and the early 60s of Myres McDougal. So many people here may know who Myres McDougal was. He was quite a renowned American international law professor, but he was also a property professor, interestingly. And he taught at Yale Law School. He was founder of the New Haven School of Jurisprudence. And he wrote quite a bit, as you can see here, on space law and what the legal regime should be. The most important thing he wrote on this topic, and a lot of his work was co-authored, but I am going to just refer to it as McDougal's work. But the most important thing that he wrote was this book in 1963, which I got a copy out of from the basement of the NYU Law Library. And this was written by McDougal and Lasswell, who also was very important to the New Haven School, Ivan Vlasic, who later became a professor of international law at McGill. And so this is like a 1,000-page tome, okay? And I did not read the whole thing, but I read a few of the chapters. And in this book, they do actually talk about, they do set out different ideas and include recommendations for what should be a legal regime for space resources. So what I'm going to do, so this is a photo of McDougal here, okay, and just to give you a sense of him, okay. So they're basic, and they're writing, so just important to keep in mind that McDougal is writing before, most of his work is before the Outer Space Agreement, okay? But already by the time he's writing, the basic framework of the Outer Space Agreement has essentially been agreed, okay? And and he's writing basically in support of these sort of conventional wisdom. So I sort of view him as setting out what the conventional wisdom was of his time, which later gets codified in the Outer Space Agreement. And then, interestingly, he offers a kind of proto-economic defense of this conventional wisdom, okay? And so what I do in my paper is I kind of restate the way that, summarize, in other words, the sort of categorization of space resources that McDougal offers, and the sort of proto-economic rationale he offers for what should be the conventional rules, or what are the conventional rules by this point for governing these space resources. And then the second thing I try to do in my paper is to draw some lessons for today from this reading of McDougal, okay? So I think that a basic starting point to keep in mind is that McDougal and his co-authors argued that space generally should be open to all, okay? So they favored an open access regime, which is basically the regime that was enshrined in the Outer Space Treaty, okay, they did contemplate that there might be a kind of justification for some property rights to emerge in some resources, okay, but they thought that might only be justifiable in the future, okay. So you can see this as broadly consistent with US policy and what was enshrined in the Outer Space Treaty. So one of the big critiques of the New Haven School was always it was kind of a way of justifying US policy, and you could kind of say that is a critique applies here as well. Okay, so let me start. So again, as I said, first I'm going to sort of describe this vision that you see for what should be the law of governing space resources and the economic defense you see of it in McDougal's work. And then the second part of my presentation, I'll try to draw a few lessons, okay, from this, this early legal vision for space resources. Okay, so what's interesting about McDougal, at least to me as somebody who was kind of educated by property law scholars who were influenced by law and economics, is you see in McDougal's work, he's already drawing on economic analysis, like before economic analysis gets mainstreamed in US legal scholarship. So he, in his chapter, in this tome on space resources, he draws on the work of this German-born natural resources economist, Siegfried, I'm probably going to mispronounce this, apologies, Siegfried von Ciresi-Wantrup, okay, and he says, well, we should think about 3 categories of space resources, okay? So I think this is actually an interesting move to think about, well, space is not just like one big blob out there, there's different kinds of resources, and the idea is that, well, the legal rules should, track in some sense the nature of the resource, okay? And so what are the two, although as I've kind of alluded to already, basically McDougal, notwithstanding the fact that he categorizes the different types of space resources, says that at this moment in time, the basic ideal rule is a rule of open access for all the types of resources, okay? So he gets from the economist the categories of flow resources and stock resources, and then he comes up with this idea of spatial extension resources, which is kind of interesting, I'll get to in a moment, okay? Okay, so let me just take you through, well, what does he say about each of these categories of space resources, and how does he justify an open access regime, okay, for all of these, in the end, for all of these space resources, all of these categories, okay? So I think the basic idea, the basic test, okay, that he uses to justify open access in the end for all of these space resources is sort of the idea that, captured in the last bullet here, that at least at this particular moment in time that he's writing, the amount that any one person or entity, like could be nation state, would use would not really reduce the amount that's available to others, okay? So, and he suggests, well, given the vast quantities and that any use conceivable now wouldn't reduce the amount available to others, the resources should be open access because leaving them open access will enhance the production, the value of what can be derived, okay? So this is kind of interesting. Okay, so then how does he sort of say, well, okay, this is true for these 3 categories of space resources that he's drawing on? Okay, so first the category of spatial extension resource. So this is the category that actually McDougal kind of comes up with, okay? So basically, this is one of the 3 categories, not from the Economist. Okay, so this is a category of resource which he describes as useful for transportation and communications. So on Earth, it would be like major roads or major rivers. In space, he talks about the void of outer space or the surfaces of the celestial bodies. Okay, and he says, well, these should be open to all in space because, again, no one's use at this particular moment in time is going to, mean there's any harm done to anybody else, any other user. And this will be better, for in terms of maximizing the production, the maximizing what knowledge can be derived from these space resources. Now, and what reading McDougal emphasizes is that there was more debate about the potential that you could have sovereignty over the surfaces of the celestial bodies than the void of outer space in the late 50s and early 60s. And so his discussion of, well, why should the surfaces of the celestial bodies be subject to open access is kind of more interesting because he, in addition to the standard rationale he gives of no one's use of the surface of these bodies is going to harm anyone else's, for the surfaces of these bodies, he emphasizes that there could be a threat of violence. And so the benefits of carving up these surfaces are just not worth the cost, which could include violence. So he cites the Antarctica approach of, as a model to apply in space. Okay, so now what about the category of flow resources? So it's interesting to see what he describes as a flow resource. Like you would usually think of a flow resource as a non-renewable, as a renewable resource. And he does actually use the term renewable resource as well as flow resource. So he thought of meteorites, asteroids, the atmospheres of the celestial bodies as flow resources, okay? And he said, again, well, they should be open to all, because generally speaking, anyone's use of one isn't going to affect what's left at this particular moment in time, okay? Now, he did recognize that there could be some flow resources where human uses could reduce what should be, what would be left for others. And then he suggested a scheme of organized inclusive use, okay? So there's a lot of vagueness. This is like one of the longstanding critiques of McDougal. So, but it's just interesting to see that he did recognize, well, maybe at some point flow resources would have to be subject to something other than open access. Okay. Now the third category of stock resources or non-renewable resources, the ones that are probably most relevant to our discussions at this conference. So his premier example on Earth and in space of the stock resource was minerals. Okay, so these are limited in quantity, and because they're limited in quantity, there's this potential, obviously, that use by one would reduce the amount that's available for others. Okay, so he distinguished two situations. When demand for the resource did not exceed the supply, then he thought they should just be open access. Okay, so when there was enough supply to meet the demand, he thought just leave these as open access, which is essentially the situation, at least at this point in time. And one might argue, given how nascent the space mining industry is, that actually maybe the demand probably doesn't yet exceed the supply. Okay, so, but now McDougal also discussed the scenario, though, when demand does exceed the supply, okay? And then he thought that some exclusive claims, what we might think of as private property, would be justified, okay, if they were necessary to secure investment to generate the mining, okay? But he didn't favor, like, unregulated private property rights, okay? So he had these caveats, okay? So this is a little bit like Anna's presentation in a certain way, in a strange kind of way, okay? So he said, well, all states would have to be able to acquire these minerals, okay? He said the mode of acquisition would have to be regulated, okay? Community interests couldn't be harmed. And then he said, well, there's also this, what he called a strategic category, a category of strategic stock resources that should be shared or subject to organized inclusive use by an international body that can make sure that each claimant gets their fair share, Okay, so this sounds like a lot of like the regime that you said was normally justifiable, okay, for this category of strategic resources. And I won't go into what he defined as strategic resources. Well, I guess I am kind of, but anyway, it's on this slide. He said, well, if a resource could be used for rocket fuel, for food, for water, oxygen, to make nuclear energy, those were the strategic resources. So, of course, he didn't know what people know about today about the South Pole of the moon, but maybe in his framework, the South Pole of the moon actually would be a strategic resource today, okay? Okay, so just a note on the process that McDougal set out for the development of space law, okay? So McDougal thought that space law would and should evolve gradually, mostly through custom, okay, rather than multilateral agreements. He did not think that multilateral agreements would really be that useful in the development of space law, okay? He kind of offered a few reasons for favoring this reliance on custom, okay, and gradual evolution. One was human knowledge of space is very nascent, so hard to draft a multilateral agreement. And he also thought countries would only focus on issues involving space when the circumstances required it, okay? So they wouldn't be well positioned to kind of develop an international agreement because they just wouldn't have the attention span or the bandwidth to do it until they were confronted with particular issues, okay? Now, there is some recognition in his work that allowing the development of space law to occur through custom would likely favor the major spacefaring countries, okay? I wouldn't say that in the work so far this is a very prominent recognition, but there is some recognition that this approach to lawmaking will favor countries like the US or, the Soviet Union, okay? Okay, so now having spent a lot of time talking about, well, what did McDougal write in the late 50s and the early 60s? So what might this vision, of space law, and in particular the law governing space resources, because he dealt with a lot more issues than what I'm talking about. He also dealt with, just to go off on a little bit of a tangent, he also dealt with the question of, well, if humans encountered other forms of life, what does that imply for the law? Okay. Anyway, okay, so what might be some lessons from what I focused on? Okay, so I sort of derive 3 lessons, okay, very tentatively. One is, reading McDougal made me think, we have to be very humble as scholars and policymakers, okay, in thinking about what space law should be. Okay, so he was prescient in certain ways. Like there's an interesting reference to space being used for weather control, which you might think of as foreshadowing its use for geoengineering. So there was a way in which he was quite prescient, but he got things wrong. There's certain things he just didn't know, like about the South Pole of the moon. How could he have known that? But he also got things wrong. He really didn't appreciate the significance that communication satellites would have, okay? Even though he wrote about satellites, and obviously satellites were very important in this period that he was writing, he didn't appreciate that, all these mega constellations of satellites that we have now in LEO, right? Or even the significance of satellites in GEO. So that meant that he didn't really talk too much in his discussion of space resources about orbits or spectrum and then how they should be allocated. Even though like today, those are like the really important, valuable resources in space, are frequencies and the orbits. It's not really the physical, tangible things like the stock resources or the flow resources that he did spend a lot of time on, okay? So that just made me think that, well, we also should be modest because it's possible we might be focusing on the wrong things, right? Okay, so a second thing that a second lesson that I sort of took away from McDougal's work was he actually offered what I thought was a very compelling case for this open access regime, okay? And I think one way of thinking about what he's saying is, well, open access is a defensible regime as long as basically the benefits of open access exceed the costs, okay? So, and that we should only move away from the prevailing open access regime if we think that the benefits of moving away will exceed the costs, okay? So this is, so the question is, well, how to apply that idea, which in the current context? And I guess when I was thinking about, well, what does this mean in the current context, my kind of intuition was, well, this would mean that essentially open access should probably remain the dominant regime, legal regime for space resources today. And that when we're thinking about moving away from open access, we should probably think kind of about identifying particular resources or places in space where maybe the costs of the current legal regime suggest something else than open access should prevail, okay? And so what are some of those areas today where we know that the costs of open access seem quite high and we should be moving away, okay, from open access? Well, low Earth orbit, okay, it's probably one of those areas where we need a better developed governance regime, given all the mega constellations, given the kind of potential interest in using low Earth orbit for more military purposes, okay? So low Earth orbit. Maybe the South Pole of the moon, okay? Maybe resources, mineral resources on asteroids on the moon, but the South Pole, these space mineral resources on asteroids, those are still quite speculative, those uses. So it's not, I think it would be hard to say that as of today, the costs of open access are so high that we need to move, given that there's not that much occurring today. Okay, so I guess the question is, well, what do we think is going to be happening, in the near future? But still, okay. So the other thing to sort of keep in mind here is that another lesson that I kind of drew is that in McDougal's work, when he suggested that some departure might be justified at some point because the cost of open access exceeded the benefits, he didn't favor unregulated private property rights. So he was not offering, in the early 60s, a kind of rationale for these national laws that you see in a few countries that others have discussed, saying you can have private property rights in space resources, right? Because those are just basically granting you absolute property rights. That McDougal didn't rationalize absolute private property rights, okay? He thought there should be limits, like I was saying before. He thought that all countries should be able to get these resources, that there should be some kind of equitable limits on how much you could acquire, okay? So the point here is that even if you think you should move away from open access for because the costs exceed the benefits, that doesn't mean that you should move to absolute private property rights. There's interim options, okay? Okay, so the last lesson that I took from reading McDougal was that I think that McDougal sort of usefully teaches that economics probably should be an input into the development of space law. I would actually, going back to Anna's presentation, there was economic analysis in Anna's presentation as well, okay? Now, he offered a proto-form of economic analysis. Today, economic analysis would be much more sophisticated than what McDougal was offering, okay? And he was not just advocating the use of economic analysis. He also took into account many other perspectives in this tome. I was just highlighting for you the kind of economic component, okay? I think, though, that you get a sense of some of the value of thinking in economic terms from his proto-form of analysis, right? This is suggesting to us, well, think about the costs and the benefits, and think about the different potential options that might enable you to realize the most net beneficially option. Okay. But one reason I think that McDougal kind of realized that yes, economics has value in thinking about what the legal regime should be, but it should just be one input, as it was in his approach to space law, was because I think he realized there were profound moral questions embodied in the development of space law. Okay, and you see, even within his economic analysis, there are embedded with them profound moral questions. So the question, sort of the test in his formulation for when you move away from open access, right? I've repeated this several times already. The test is, well, are the costs of open access, are they sufficiently great, right, that they're exceeding now the benefits, okay? Well, there's a moral question embedded in there. What are you going to count as the costs? What are you going to count as the benefits, okay? And so that's one reason why economics can't provide the sole answer, but it can be, it's a useful input, I think. And I think one thing to maybe think about for the international space law regime is how might economic analysis be incorporated into the development of space law? So right now at Copus, you have, and you had for many years, the legal subcommittee and the science subcommittee. You could have an economics subcommittee that maybe could give you some valuable information, right, about what are the costs and the benefits, over some period of time of space mining, okay? You wouldn't use that as the only information in deciding what the legal rule should be, but this could be a valuable input, okay? Okay, so I will end there and look forward to the discussion. Thank you.
Thank you.